No. Good afternoon, Ms. Brahma.
Good afternoon, my lord. Our first witness this afternoon is Dr. Marsha Scott. Oh, apologies, I'll speak up. Our first witness this afternoon is Dr. Marsha Scott.
Very good. Good afternoon, Dr. Scott.
Good afternoon.
Right, when you're ready, Ms. Brahma.
Thank you, my lord. Dr. Scott, I just want to confirm that your name is Dr. Marsha Scott.
Yes, it is.
That you are the CEO of Scottish Women's Aid.
Today, anyway.
And you provided a statement to the inquiry dated the 30th of September 2024. For the record, the statement reference number is SCI WT 0119-501. Now, you previously gave evidence to the inquiry in November 2023 as part of the Scottish Women's Rights Organisation. So we are aware of your role within that, but could you please briefly remind us just of your own background and give us a brief description of Scottish Women's Aid?
Scottish Women's Aid is a national strategic intermediary, a term I'm sure you're all very familiar with. So we have two basic functions, which is we serve as an umbrella for the 33 women's aid services that are around Scotland, supporting them and getting data feedback from the front lines from them. We run Scotland's domestic abuse and forced marriage helpline, which receives about 12 to 15,000 calls a year, and we spend an awful lot of time talking to officials and parliamentarians about how they could run Scotland better in order to do a better job of responding to domestic abuse.
Great, thank you. Now, in paragraph 32 of your statement, you say that Scottish Women's Aid became increasingly concerned about the harm to staff and service users, leading to action to be taken ahead of any national measures being put in place by the government. What actions did it lead to in order to ensure ongoing service provision, both at the umbrella organisation and at local women's aid groups? We're an organisation staffed by women, and we're an umbrella of organisations that are staffed by women. Women are more likely to use public transport than men are. We were increasingly aware of the danger to our staff of having all of whom use public transport to come to work in the middle of Edinburgh. And the looming pandemic made it very clear that this was not something that was going to disappear. So we were very concerned about the ability to continue to provide helpline services, which was very technologically dependent on the arrangements that we had in place in our offices. So we made a decision earlier than the government did to close our offices, to make the transition to working from home, and to essentially implement what was a 5-year plan for increasing our technological capacity for our helpline, which was implemented in 5 weeks. So it was about just trying to forecast what was coming and be as prepared as possible. The day we decided to close our office, we communicated that decision to our network. They were, most of them, considering the same things. They all had women who were, concerned about their unpaid care activities and looking at what was happening in other countries. But we were the first to close officially, and some of that was a function of being in an urban centre. Yeah. Thank you. You mentioned in your statement the funding that you received from government. How vital was that funding, and how important was the timing of that funding to ensure ongoing services?
Do you mean the COVID emergency money or the existing funding picture before the pandemic?
I mean the COVID emergency funding, but if you think the prior funding is relevant, then...
It is indeed. So
the situation as we went into the pandemic was that since austerity, really, and around 2010, our network of services had suffered a salami slicing of funding for local services, and the centralized funding that was coming from the Scottish government, while more stable than the local funding, was on a level funding basis, so a year-to-year cut, and that was particularly acute, obviously, when inflation went up. So it was a very vulnerable network prior to the pandemic, and the ability of the Scottish Equality Unit, and I have to really call out how grateful we are to their ability to act quickly with COVID emergency money, and in particular, Minister Christina McKelvey at the time, who reached out to all of the violence against women organizations and in a really speedy and responsive way. I'm not sure I could say that about the local authorities, certainly, or the other elements of government, but I think they deserve a lot of credit. I am a CEO as part of a four-nation group of women's aides across the UK, and I can tell you that Scotland was the only place where that was true.
Now, you state in paragraph 64 that the inconsistent application of key worker status and allocation of school spaces led to some staff members not being able to work. Did that ever result in refuges not having staff or other services not being able to continue? And if so, was it resolved quite early on?
Not one of our services closed completely during lockdown, but there was absolutely a lack of being able to provide services the way they had been. And one of the major contributors to that was the fact that without key worker status, there was no place for their children to go to school. And they were also being asked to do the at-home care work around education, and if your children are very small, there's no nursery available, et cetera, et cetera. So I think, when we talk about gender competence all the way through, one of the things that we have to really stress is from the beginning to the end of the pandemic, there were impacts on women and children that were more disproportionately harmful. And that's based on the social status that women and children have in Scotland.
Thank you. And you go on actually at paragraph 42 to say that Scottish Women's Aid was extremely concerned from early on about the disproportionate effect of the pandemic and lockdown on women and girls or children, particularly those experiencing domestic abuse. Can you provide us with some examples of the disproportionate effects and explain why those are based on gender rather than any other factors?
This is a bit of a long answer probably, but everything from the failure to prioritize domestic abuse in the civil and criminal justice system's response, which is fairly confusing, given that we know that domestic abuse is the most common site of business for both the Crown Office, the police, and the courts. So the failure to risk assess the actions that were made in terms of the differing impacts on women and men meant that we had decisions that were made that had a much more harmful impact. So, for example, court closures or court delays, given that the domestic abuse is overwhelmingly experienced by women and children, and the fact that it is they're needing access to refuge, for instance, in order to have emergency accommodation, is because we don't find ways to keep them safe in their own homes. And that problem in itself was a massive disproportionate impact on women and children, because they're made homeless very often in Scotland if they're seeking safety from domestic abuse, because we have never fixed the way we allocate housing and the way we respond to perpetrators. So domestic abuse is the single biggest cause of women's and children's homelessness, and the whole system for housing was focused, and during the pandemic particularly so, on rough sleepers who are predominantly men. So you can see that it's rolled up into every element of Scottish life. And when you're in a crisis situation like a pandemic, people default to the easy answers. And so if we had had a response that across the public sector had been in line with our duties under the public sector equality duty, then the actions would have been equality impact assessed competently from the beginning, but they really pretty much never were.
Thank you. Now, you state at various points in the statement, and you touched on it there, that issues such as domestic abuse and financial difficulties faced by women and girls were exacerbated by the pandemic, and this in turn seems to have led to an exacerbation of difficulties in accessing both civil and criminal justice. The key issues you speak about, which require to be addressed through civil means, appear to relate to child contact arrangements, which were challenging due to a reduction in the number of legal aid solicitors. And the key issues requiring to be addressed through the criminal justice system related to domestic abuse, which you say was affected by policing and court capacity. And of course, there may have been an interplay between these two. And I'd like to look at each of those in a little more detail. So first,
good. I didn't want to have to remember all of that from the beginning. Go ahead. Thanks.
So first, looking at civil justice, can you tell us what the key problems relating to child contact arrangements were?
This is sort of a complex area of civil processes and civil law. In terms of child contact, so this is not a peripheral or niche sort of issue in terms of domestic abuse. It's the single biggest legal issue that women raise with our helpline. And I know when you hear from the Scottish Women's Rights Centre, they'll tell you that it is very commonly raised in the cases that they deal with and that the women who call their helpline. And in terms of access to civil justice, from the very beginning, women suffer a disadvantage in the sense that the way that our legal aid system is set up, and I'm sure you will hear lots about the failure to fund legal aid appropriately, but even the way the system is set up, it's inappropriate for domestic abuse cases. So if you're a woman who is going into a civil process around child contact, for instance, and given the inequalities in Scottish life, you are much less likely to have access to an independent income and to be able to hire a good lawyer. So that's why legal aid is set up, you say to yourself. However, between the fact that so much finding a legal aid lawyer was difficult before the pandemic and became virtually impossible during the pandemic. And when women could get a legal aid lawyer, for instance, if you were in a rural or island community, that legal aid lawyer was almost always located in Glasgow or Edinburgh, and they were taking dozens and dozens of cases, and we heard lots of stories about solicitors mixing up clients because they had so many. And then on top of that, if you're a woman trying to separate from an abuser, legal aid only covers some of the needs that you have. So you need to know what your tenancy rights are. You need to be counseled and supported in the negotiations around distribution of the family assets. There are a whole set of things that legal aid doesn't cover. So it may cover child contact if you can find somebody to represent you. And we're still, in the an emergency situation where women are having to represent themselves, which is really dangerous. And absolutely goes against the commitment of the justice system to a trauma-informed approach. So I am now forgetting what you asked me. But in terms of child contact, so one of the things was that just an absolute vacuum of access to good, competent, adequate legal services. Another was that the child contact centers, for the most part, were closed down with no accommodations made for what was going to then happen. We had, I think I mentioned it in the report, that one of the women called the helpline to point out that an official had said to her that she better just make contact arrangements directly with the abuser now that the contact center was closed, or she might be considered in contempt of the contact order. I mean, we had dozens and dozens of stories like that where the abuser didn't bring the child back, claiming that it was too dangerous to travel, or one woman was stalked by her abuser on the grounds that he didn't believe that she was protecting the child from COVID, and there was no response to that. We had, stories about women calling the police to say they were threatened and in concern about their physical and emotional and the child's safety in the handover of child contact, and the police would say to her, "That's a civil matter. That has nothing to do with us." So I can't tell you how many different kinds of ways in which children and women were put in more danger because of the failure of the system to understand that contact is one of the most dangerous places for women and children in post-separation contact in the context of domestic abuse. Did I cover what you asked me?
Yes, you did.
Oh, good.
Now, in paragraph 77, you're speaking about, you touched on it there, children being returned to the mother, essentially after contact has taken place with the ex-partner. In that context, on page 24, the second line from the bottom, you state that the Scottish Women's Aid is working with Police Scotland to develop effective guidance for dissemination within our respective networks, but options are limited, especially in the absence of clear domestic abuse-specific guidance for criminal and civil courts and child welfare professionals. Are you there referring to specific guidance by the Scottish Government? And if so, what kind of guidance do you think would be helpful in that situation?
Well, we were desperate for someone who had standing in the criminal and civil justice sectors to provide some support for the frontline police officers, for the women's aid staff who were seeking to get legal services for women and children, for the school officials who were thinking about what the impact on children would be of closing their access to schools. I mean, there were a whole set of unanswered questions for an awful lot of those professionals. Mm-hmm. That begs the question, they should have known the answer, most of them. However, they didn't. And so the obvious place for us to go was to look for the Scottish Government and for the bodies that they oversaw, whether it was through the Crown Office or through the Scottish Legal Aid Board or through the Scottish Children's Reporters Administration, whoever it was, to help set up, these are the things, these are unprecedented circumstances in terms of the pandemic. This is guidance for making safe decisions and for prioritizing the rights of the people in front of you. So clearly contact orders need to be followed as a legal order, but in unprecedented emergency situations, this should be true the rest of the time, but it's not. The safety of the child and of the woman should be the paramount consideration. But so many of the professionals in the process didn't have that as a risk assessment approach, and so the guidance from any of those actors would have given the the folks at the coalface confidence that they could make the decisions that would keep women and children safe. But the wheels of that turned very, very slowly, and it was very, very difficult for us, other than to have, sort of bilateral conversations with the police, with the local authorities, et cetera, to get them to acknowledge how much risk there was in the practice that they were engaging in.
On the next page, in the next subparagraph of paragraph 77, you state, the government has an obligation to act in the best interests of the child and to protect children from all forms of abuse. Now, this is in the context of ex-partners not returning their children to their mothers. Are you suggesting here that the ex-partners are abusive to the children, that not returning children to their mothers is abuse in itself, or something else?
Sort of all of the above. I have to say, I'm not saying that every convicted domestic abuse offender is abusive to his children when he has contact, but I will say that there is libraries of evidence that that is a very dangerous time for many women and children, and that we have already existing in Children's Scotland Act and in other legislative other laws that indicate that domestic abuse is a special case when making contact decisions, and that contact should not be ordered unless the judge or the sheriff is confident, or the children's hearing, confident that it will be safe. And the difficulty from our perspective is that not only does it happen routinely anyway, but in the context of the pandemic, it I think was whatever the easiest out was the one that would be taken unless there were clear guidelines about this. So in other words, sorry, I'm swithering. In other words, the paramount consideration should be the safety. And if there was any lack of confidence that the order, the contact order, the complaint to the police, whatever it is, would justify controlling or pursuing a father who hasn't returned his children, then that should have been done. And there are cases where women didn't see their children for a month after, because of all of the reasons. We had cases where the offender had claimed that he had COVID 4 times in the space of 6 weeks. So there's a whole variety of excuses that could be used. And, I am not saying this was in all cases all the time, but what I'm saying is we have so much evidence that this is a site of heightened risk, that there had to be decisions that were made with the priority of safety in mind.
Thank you. Now, you finished that subparagraph by stating, this requires ensuring there is clarity on which officials should respond and the process to follow in situations where women report that abusive ex-partners have failed to return their children. There should also be a mechanism put in place to ensure consistency in response across the country and equal protection of children irrespective of where they live. And you briefly touched on it there. What sort of mechanism do you think it would be beneficial to have in place? Practical mechanism, particularly in a pandemic setting. So where someone says, I've been unwell, this is a risk. What could be done then?
I think this gets back to our point about being competent around domestic abuse, which is to understand what all the evidence that says about the way that domestic abusers manipulate the courts and civil processes, and not necessarily to assume that that's what's going on, but to understand how very prevalent that is, and to make decisions, especially in the context of a pandemic, based on that evidence. So what's a safety? What are the mechanisms of ensuring that there is safe contact? And if you can't put those in place, and very often during the pandemic they couldn't, then no contact should happen. Now,
that doesn't mean that no contact should happen after, lockdown or any of those things. But if our priority is the safety, is our paramount consideration is the safety of children, surely those decisions would have been made differently.
Thank you. A systemic issue you raise in relation to civil justice is access to solicitors who practice family law and accept legal aid work. And you state at paragraph 88 that women solicitors are overrepresented in family law and that women were disproportionately impacted by labour market changes as a result of lockdown measures and were less likely to return to work after the pandemic. And you stated in your statement that Women's Aid staff reported making up to 50 calls before they could locate a solicitor for someone. I wonder, has Scottish Women's Aid seen data on this, or is this down to practical, each service's
Evidence
experience
from the
of
ground,
dealing? Yeah.
both really. We've been working with the Scottish Legal Aid Board to try and address increasing access or increasing the referral process. But there's been no evidence that the problem is doing anything but getting worse, frankly. And there was a case in the news last week, I think, about a woman who made 120 calls or something. This is a problem that existed before the pandemic. There's absolutely no reason to think the pandemic caused it. I think Close the Gap, which is a labor market or organization with labor market expertise, can point out what we do know and don't know now about what the state of the labor market is, especially for women. But we do know, as we cited in the report, that that women were among the first to be put on leave. I've just lost the word.
I think in your report you mentioned furlough.
There you go, furlough. And the last to be taken back, and also many of them, because of the additional caring responsibilities that they had at home, chose not to come back. So, all of the sort of, what's the word? The pressures that would be on women solicitors were also on women's aid staff, and on victims and survivors themselves, who were trying to hold down professional jobs or not, or being put on furlough. And when we look at that in the context of women's disproportionate likelihood to be poorer, and to have less access to legal services, it's a bit of a perfect storm.
Does Scottish Women's Aid have a view on how that could have been addressed during the pandemic? I mean, specifically the lack of availability of legal aid family law practitioners.
Well, I think there's no quick fix for that. So during the pandemic, it would have been very, very difficult, I think, to suddenly magic up more solicitors or to stop the bleeding of the solicitors out of the system. So I don't really know exactly what I would have had them do then, but what I would have them do to have fixed it ahead appropriately. The legal aid model is not appropriate for domestic abuse cases. As I mentioned before, it funds little bits of a woman's legal needs, and it exacerbates her likelihood to be poorer and to be harmed by the outcome of civil and criminal processes. So certainly we went in with a dire situation, and it just became more dire, direr. So I'm not convinced that there weren't things that could have been done, but I don't think there was a quick fix, to be honest.
Thank you. Now, moving on to criminal justice, you state at paragraph 85 that access to justice for victims / survivors of gender-based violence was severely undermined by the closure of courts, where trials, including for domestic violence and sexual crimes, could not be heard. This increased the safety risks facing women and children during the pandemic at a time when crucial support services for survivors of gender-based violence were altered. Now, might be obvious to some, but just for the sake of completeness, could you give us some examples of the safety risks faced by women as a result of trials not proceeding in the usual timeframes?
We have ample evidence, not least from the Glasgow Domestic Abuse Specialist Court that was set up years ago, and the evaluation of that court, that there's a window of opportunity for the courts to respond in domestic abuse cases. And when we don't get a case heard from the time of police report to the time the case is heard, when it goes much beyond 8 to 10 weeks, we begin to see significant attrition of witnesses in the cases. And the reason for that is women are less likely to be financially independent. They may not be able to put food on the table or pay for the rent or deal with the housing and homelessness challenges. They may be subjected to harassment and threats from the accused. There's a whole menu of things that increases their risk as time goes on. And we know, for instance, from that domestic abuse court evaluation, that when cases come to court in the appropriate time frame, that there's more attrition on the defense side than from the accused, from the complainer. And Scotland had spent, rather belatedly, but had spent some significant amount of time working on getting that time down. So some years before the pandemic, the average time to court was 26 weeks. And then by just before the pandemic, we were seeing more of an average of 12 to 14, which was so much better. All of that progress, which took about 10 years, got wiped out by the pandemic. And the failure to prioritize speed to court for domestic abuse cases, which were considered probably less serious, which is because 85% of domestic abuse cases are in summary court. So the investment was heavily in high court proceedings because that was the more serious crimes. The summary processes were, as you know, led to massive delays and many sort of dangerous practices associated with what were considered sensible protective, epidemic protection practices that led to things like women, complainers and accused being asked to queue in the same line outside of a courthouse, those kinds of things.
In paragraph 86, you state that court shutdowns were not communicated to domestic abuse complainers, resulting in them making the effort to get to court, sometimes with children, only to find the court building closed. In these situations, who had the complainer been in contact with? Had it been the Scottish Court Service, or had it been the Crown Office Prosecution Fiscal Service, Procurator Fiscal Service?
My understanding of what happened, and this is just the most egregious example of gender incompetence you ever saw, on the second lockdown, of which there was 24 hours notice from the court service that they were closing the summary courts, except for very few. And a very few cases would go forward, of which we heard domestic abuse was prioritized, but it was a tiny number of cases in the grand scheme of things. Mm-hmm. The court had decided to close in 24 hours, and as from what we were told by officials from the court service and the Crown Office, the notification of the fact that their cases wouldn't go ahead were made to the judiciary and the fiscals involved. The only witnesses who were contacted, as far as we knew, and as far as they knew, were the ones whose cases, in the very small number of cases that were going to go ahead, those witnesses. So what we had was an uncounted number of witnesses from around Scotland who had cases that were scheduled who never knew that the courts had been closed. And the response from the court service was, well, it's on our website. You can imagine how helpful we thought that was. So, you might have a woman who more likely to be using public transport because she's a woman with primary care responsibilities for children on a bus for 3 or 4 hours in the winter with other people. We remember the risks from public transportation, to arrive at a courthouse that is closed, never being told that that the court was closed, and arriving at the same time as the accused. There's so many dangers in all of that for women and children that should have been immediately obvious to the decision makers involved.
And
I'm not saying that the court shouldn't have been closed. I absolutely get that was a good safety response, but with 24 hours notice, I find it extraordinary to think that anybody thought that pushing the risk from the court staff onto the vulnerable women and children who were involved in those cases was justice.
And are you aware whether whether that was limited to a few isolated incidents, or was it a recurring theme that was raised with staff and
well,
with the
certainly
helpline?
we raised it. Victim support raised it with the Crown Office and the court service. I mean, all the victims' organizations were appalled, frankly, and it was a very chaotic time. We were all desperately trying to make sure that services were able to be provided as much as possible, safely and securely and consistently. And so we don't have any numbers to tell you how many times that will have happened. But considering the hundreds of domestic abuse cases that get heard in Scotland, you have to imagine that the numbers were very significant.
Now, towards the end of paragraph 86, you state that Scottish Women's Aid supported the widespread use of virtual trials and appealed to judicial and government leaders to implement them, as they would have greatly eased the delays and provided women with safe ways to engage with court processes. Is Scottish Women's Aid of the view that change to remote hearings and trials could have taken place more swiftly? And when you raise these concerns with judicial and government leaders, how were your concerns met?
It was a very, very frustrating situation for us. Clearly, remote giving of evidence is part of what the court is trying to enable anyway, and has been part of court reform. Modernizing Scottish courts. And there is really no evidence that a virtual trial or that a complainer or witness giving evidence remotely leads to a poorer trial. And in fact, we're all pretty confident. I think the Crown Office is confident that it provides better evidence because the witness is not concerned about her personal safety, about being in the same room with the perpetrator or even in the same building as the perpetrator. And in the middle of a pandemic, of course, not having to travel 4 hours on a bus in the cold with a child is going to improve her ability to stay engaged with the case and to give good evidence. The failure of virtual trials to go ahead, I think, falls on a number of actors. Only something like under 10 actually happened in the first 18 months after the first lockdown. And as far as I know, we had extensive conversations with the Crown Office on this. They were quite supportive of it going ahead. If you imagine, at the time they had a lot of fiscals who weren't going to courts because the the courts had been closed down on and off. And they were keen to see this go ahead. And the problem, no surprise, came from defense solicitors who were unwilling to engage voluntarily. And that was not a surprise to us. As we know, delays in domestic abuse cases tend to generally benefit the accused. But the failure of the system to then respond in some sensible way to that, and, you know, the solicitors who are representing the accused were doing their job. I mean, it's not that we were accusing them of malfeasance, but the reality is that there was a COVID emergency bill, and we worked hard to try and make sure that there was some language in that emergency bill that established that domestic abuse cases, given the enormous number and the huge delays that were being racked up, that it be a default assumption or a presumption that they could go ahead virtually, with obvious, you know, exceptions, and at the very least that decision could be made by the sheriff principal. We had positive discussions of that with the cabinet secretary and with a number of other people in the Scottish government. But unfortunately, when we actually saw the COVID emergency bill, that language was not included. The judicial leadership, the Lord President, could have facilitated it. It did not happen. The Criminal Justice Committee took evidence from ourselves and from the many survivors who had told us how important this was for them and for children. And yet the Criminal Justice Committee's response to the emergency bill was not to support a default for virtual trials because there wasn't enough evidence. Well, there was multiplicity of evidence about the benefits of it. So clearly, you know, from our perspective, the arguments of other actors in the legal community must have swayed those actors, but there was no good justification given for why some kind of proactive actions were taken or could have been taken that were not. And I hold lots of folks responsible for that, like they care what I think. But yes.
Thank you. Now, at paragraph 72, you state that women's aid groups reported that while some police officers demonstrated a greater understanding of the risks of domestic abuse during the pandemic and lockdown, there were significant problems because of the increased use of undertakings to court and a decreased use of remand. In some instances, abusers were returned home and committed further abuse, endangering women and children. Multiple bail breaches were common and rarely resulted in arrest. Again, the answer to this might be obvious, but for the sake of completion, what were the consequences on women and children of an accused being returned home and of the system taking that turn?
Well, the failure of the system to prioritize safety, and, you know, we argued successfully that in terms of early prisoner release, that those convicted of domestic abuse should not be released early. And clearly remand is a different legal context. And we were sympathetic and are sympathetic to the challenges of dealing with prison populations in an epidemic or a pandemic. The issue for us is if you're going to release or not order remand, then you have to have other measures prepared and ready to ensure that can be done as safely as possible, which would involve, it could be a number of things. It could be increased use of electronic monitoring. It could have been rehousing the accused in a perpetrator in a special housing arrangements for them if you weren't going to remand them. I mean, I think that what we were doing was just putting the risk. Well, I wasn't doing it. What the system was doing was saying, oh well, women and children will just have to sort out their own risk because it's too much risk for our system. So the failure to understand the consequences of remand, to be vigilant in the face that you were increasing risk, and at least to put in some measures that would have ensured that there was more safety, even in the context of abusers returning home. And then the failure to respond robustly to breaches. I mean, our colleagues in Assist, our colleagues in the Victim Support Scotland. I mean, we were all just tearing our hairs out because because the system was set up to supposedly to provide safety, and when it didn't provide safety, it did nothing.
Mm-hmm. When you raised these concerns, how were your concerns met? Did you raise these concerns with government officials, and did they refer to any impact assessments that had taken place or any other studies that had been done on these impacts? Were they of the view that there was no great risk?
I would say that they understood what we were saying about the increased risk, and we certainly shared our concerns widely, as did our sister organizations. But I think the lack of a robust or even a pro forma impact assessment made it obvious that there really was little competence to do that risk assessment and an equality impact assessment, and B, little pressure from leadership to make sure that the consequences of these decisions were thought through ahead of time. I had an official actually tell me, and this was in education, when I asked if they had done an equality impact assessment on their decisions about how they were closing schools and how they were setting up hub schools. And I was told no equality impact assessment was done, and no apology was needed because it was a pandemic, which flies in the face of everything we know about why you do an equality impact assessment.
Mm-hmm. Thank you. Now, before we move on from civil and criminal justice, are there any issues that we've not touched on that you want to highlight?
I do want to go back to, I wrote myself a little note, to the question about what could have happened in the context of their not being able to, women and services who were supporting them not being able to find solicitors. Clearly, this is not my area of expertise in terms of how you get solicitors into the system. But it does seem to me that given that women were being, furloughed in numbers from legal services, that there might have been an opportunity to work with the legal organizations, whether they were private firms or whomever, to arrange some kind of secondments or some kind of other mechanism to redirect the employment so that there would be some, at least ameliorating some of the difficulty. Now, I don't know what that could have looked like because it's not my area, but I do think that surely, just giving up wasn't the appropriate response.
Thank you. Now, I want to touch briefly on the issue of access to school spaces, which you cover in your statement. While we aren't looking at education itself in Portfolio 1, we will be coming on to equalities and human rights, and we will have hearings in that regard in due course. But I want to ask you briefly about the Scottish Government's guidance on school early learning and childcare spaces for vulnerable children and young people. In paragraph 77, subparagraph 4, which is titled School Spaces for Vulnerable Children, you state that children and young people who are experiencing domestic abuse but who are not known to child protection, the vast majority of children in our services, may be at a far greater risk of harm now than they were pre-lockdown. However, it is likely they will be overlooked for access to school spaces if local authorities are following the criteria laid out by the Scottish Government guidance. Local women's aid groups, with a few exceptions, have not been invited in local decision-making processes in regards to which children and young people in the area would benefit from access to these spaces. And then you go on to say that there are immediate and increased risks of harm, and in order to meet human rights obligations, including the right to protection from abuse and neglect, urgent action at national and local levels is needed to ensure that all children and young people at risk of harm are prioritised for school and early learning spaces. So I have two questions in respect of that, and there might be an overlap in the answers. So I'll put both questions to you, and you can answer as you determine best. First, where the children and young people aren't known to child protection, how could their needs and rights be safeguarded? And would it be a case of women's aid groups referring the children known to them, or could something more be done? And secondly, how could the involvement of women's aid groups have made a difference in local decision-making regarding children and young people? Is there a view that there's a lack of relevant expertise in local authorities generally on this topic?
So there's an overarching problem that affected both of those questions, which is the failure of most multi-agency arrangements in Scotland around child protection to include non-statutory services such as our own. And there are some wonderful, stellar examples of good practice, and Dundee, I think, is one of the ones that we cited in our report, yes. Where women's aid, because we are a significant provider of support for vulnerable women and children, are included at the table where decisions are made, such as who's going to be eligible for hub schools and nursery places, who's going to be designated a key worker, those kinds of questions. So we all, well, those of us who've done much work in child protection or child welfare understand, you know, when you look at child death reviews and all of the history of investigations into them, that the lack of joined up decision-making and information sharing is the biggest risk. And so our observation is that the failure then to include the folks on the ground who are likely to have the most information is a professional incompetence. That was the backdrop for much of this decision-making. And you can imagine that, you know, the decisions around, so schools will have had information about who vulnerable children were. The vast majority of children in schools who get services around domestic abuse get them in schools from a women's aid worker who goes to the school. And the reason for that is it's a really safe place for kids experiencing domestic abuse. You close down the school, you close down their access to domestic abuse workers. You don't put their mothers on the key worker if their mother's working for a women's aid. You don't put them on a key, give them a key worker status. And you're just essentially closing every avenue of safety and help and support for children that existed prior to the pandemic. So much for children being our, you know, most important resource in Scotland. So there were so many mechanisms through which that didn't have to happen the way it did. And like I said, it was done very well in Dundee and some other places, which is you put together multi-agency groups and you identify children who are at the highest risk, and you include in that the very significant number in Scotland of children living with domestic abuse. Estimates are 1 in 5. Okay, so, and those would be, alongside lots of other children. There were certainly ways you could manage that would not stigmatize children and families, but that would help keep them safe and have allocated spaces. It would have missed some children. There isn't any question that not all children are in the service system, but we certainly could have done a lot better at supporting and protecting the ones who were. And then the failure, absolutely, to put women's aid staff consistently across the country on key worker lists was again we had, the disproportionate impact on women of some of the decision making. And, we talked firmly to officials in education and the Scottish government about our concerns about the inconsistency of decision making around key worker lists and how they were implemented. And there was some attempt, I think, to do some influencing internally and with COSLA to make sure that people were considering women's aid. But it happened very inconsistently and not. I wish I could say that it all improved and it was fine across the country, but that was never the case.
You've only got 6 minutes left, Ms. Brown.
Thank you, my lord. With a view to the time, I just want to ask you one final question. In paragraph 142, you state that those in power must consider the human rights of those most likely to have their rights violated and to ensure that decision-making involves intersectional gender competence. Despite overwhelming evidence on the gendered impacts of COVID-19, Scottish Women's Aid's view is that there was a general lack of gender competence in decision-making at both the UK and Scottish Government level. Is your opinion that the lack of gender confidence affected all the issues that we discussed today? And if so, how could gender competent practices make a difference? Are you able to provide some practical examples of what that would look like?
I wish I could point to an element, to a section of government or public sector practices that were good practice examples. But I will say that I know gender competence, I'm sure people are rolling their eyes behind my back sometimes when we talk about it. But all of the things that we've talked about in the last hour relate back to the understanding that women's and children and men's and boys' and girls' lives are very different in Scotland. And that if you want to design a service or an intervention or a law or a policy that is competent for all of Scotland's people, then you have to understand that essential principle. And our public sector equality duties and the special obligations in Scotland under them make it clear that the expectation of policymakers and service providers who are spending the public pound is to have at least a basic competent understanding of how those things operate and to accommodate, mitigate, and promote equality in every decision that they make. That's not rocket science. That's just understanding that you need to have some concept of who you're providing services for or planning services for before you decide to go ahead and make what were sometimes always very difficult, but just ridiculously blind to the consequences on lots of institutions' parts. So I guess the thing that I would say, what's the most important thing that people can do is to get a grasp of who are the people you're serving. What do you know about them? What do you know about their ethnicity? Are they disabled? Are they children? Are they any of these things? And what's your obligation to mitigate the oppressions that they're experiencing, and to help us create a Scotland that we all want? And that sounds aspirational, but it just takes everybody doing their job competently, which really shouldn't be too much to ask.
Thank you. Is there anything we haven't covered today that you'd like to briefly highlight at this point?
No, I think you've probably heard enough.
Thank you very much.
Thank you.
Thank you, Ms. Brummy. Thank you, Dr. Scott. Very good. Come back at 2:45, 3:45, I beg your pardon. Good afternoon, Mr. Gill.
Lord, good afternoon. The two witnesses this afternoon to conclude are Miss Lindsay Fleming and Miss Sabrina Galella, who are representing the organisation JustRight Scotland.
Good afternoon, ladies.
Good afternoon, Lord.
Yes, Mr. Gill.
Thank you, Lord. Ms. Fleming, first to you. Your full name is Lindsay Fleming, is that right?
That's right.
And you are a senior associate solicitor at JustRight Scotland, which we'll call JRS for brevity today. How long have you held that position?
I've been at JustRight Scotland for since 2018, so around 7 years. But I've also been a volunteer at the Scottish Women's Rights Centre, which is a centre that I sit in, since it began in 2015.
We'll come and look at the overlap between JustRight Scotland and the Scottish Women's Rights Centre in a moment. Your background, as you tell us in your statement, which I'm sorry, my lord, I forgot to give the reference to. The statement is SCIWT 0177 and 501. Your background, Ms. Fleming, is that you are a qualified solicitor and you have a particular interest in civil legal aid and also within the area of gender-based violence.
That's correct.
Your academic background is that you have a BA in Childhood Studies and you have an LLB in Scots Law with a practicing diploma.
That's correct.
Ms. Galella, you are Sabrina Galella, is that right?
That's correct.
And you are the Policy and Public Affairs Manager of JustRight Scotland.
I was.
You were. You told me that the other day, and apologies for forgetting it. What was the period during which you held that role, and what role do you hold now?
I started at JustRight Scotland in September 2021 until September 2024, so I stayed for 3 years. And I now work at UNICEF UK.
I see. Thank you. Your background is in policy and public affairs. You had a background of working in the third sector in that context. And you have also been a researcher at the Scottish Parliament.
That's correct.
Your academic background is that you have an undergraduate degree in politics and international relations, and you have a master's in law in international human rights law, and you also have a specialist diploma in public affairs.
That's correct.
Right. Obviously, you come to this hearing with two slightly different perspectives, one as a practicing lawyer, the other as a policy advisor. And as we go through various subjects in your evidence, some will be more relevant to one of you than the other. But please, during answering questions and discussing matters, where you feel that you can add something to what your colleague has said, please do so. And can I also say that we have your statement, which I've now made reference to. We will look at one or two of the matters that you've referred to in that statement in some detail this afternoon. But your statement is before the inquiry, and everything that's within that statement will be taken into account by the inquiry and by His Lordship as we move on into reporting and making recommendations. Can you tell me a little bit about JustRight Scotland? What is it?
Yes, so JustRight Scotland is a registered charity that was set up in 2017 by a group of human rights lawyers, and the purpose, the principal purpose, is to extend and defend people's rights, working collaboratively with lawyers and non-legal organisations to promote access to justice, reduce inequality, and also to develop models around social collaborative justice. JustRight Scotland has 4 separate legal centres, each of which provide different legal advice and representation. There's the Scottish Refugee and Migrant Centre, the Scottish Anti-Trafficking Centre, and the Scottish Just Law Centre, and the Scottish Women's Rights Centre. Mr. Gale, I don't know if you want me to explain how the Scottish Women's Rights Centre sits in.
You've set those out in paragraph 9 of your statement, those 4 organisations, and I think just in general terms, the organisation JustRight Scotland has as its purpose assisting those who perhaps do not otherwise obviously and easily have access to justice and the justice system. Would I be correct in that?
Yes, that's correct.
Yeah.
JustRight Scotland aims to represent and support those who are underrepresented and marginalised in communities.
Just tell us a little bit about the 4 national centres that you refer to in paragraph 9 of your statement, please.
And if you'll allow me to refer to my notes to just make sure we're getting everything correct. So we have 4 legal centres. The Scottish Refugee and Migrant Centre assists women and children, and also deals with areas such as destitution and family reunion. Through outreach and representation, the SRMC Centre, which is the Scottish Refugee and Migrant Centre, has a focus on immigration and asylum law, but with additional focuses on the childcare system when dealing with children, and other areas that would affect women, such as FGM, forced marriage, domestic abuse, and anti-trafficking. And they also, as I said, deal with family reunion applications, age disputes, and also legal advice around migrant destitution.
Good.
Our Scottish Anti-Trafficking and Exploitation Centre provides specialist legal advice on all matters relating to an individual's experience of trafficking or exploitation, which can include protection of that individual, compensation, employment law, criminal justice, and also immigration and citizenship. We also have our Scottish Just Law Centre, which provides legal advice and representation under the Equalities Act 2010 and the Human Rights Act 1998, using civil processes to focus on strategic public interest discrimination and human rights casework. And then finally, the centre which I sit in is the Scottish Women's Rights Centre, and that assists women who have experienced gender-based violence in Scotland. It focuses on the civil justice processes around that, but also providing some information around the criminal justice system, and the areas such as family law, personal injury, and divorce and other areas such as child contact.
Thank you very much. I think we can see in paragraph 9, under reference to the Scottish Women's Rights Centre, that you say it's a unique collaborative project delivered through a partnership between Rape Crisis, amongst others, Rape Crisis Scotland, and obviously we heard from Ms. Brindley this morning from that organisation. Now, today, and indeed in earlier hearings, we have heard from a number of organisations, and within the evidence that we've heard, there are some common themes that are emerging. I think I can indicate that to you. And you address certain of these in your statement. But before I get to those themes, can I just ask, do you actually provide legal advice to people? And are you able to provide that advice through your own organisation, or do you have to refer it on to a professional solicitor in private practice?
Yeah, so if I could just explain a little bit more about the Scottish Women's Rights Centre, I can explain the context behind how we deliver that advice. So the Scottish Women's Rights Centre, just as you have said, Mr Gale, is a partnership between 3 different organisations. And JustRight Scotland is one of the partners within that organisation that provides a legal tender for the Scottish Women's Rights Centre. We are able to provide advice and representation. So we provide advice and information to survivors of gender-based violence through our outreach. So we deliver helplines and legal surgeries, and we're also able to provide legal representation on a limited basis for survivors, and that advice and representation is provided directly through the Scottish Women's Rights Centre legal services, which are tendered to JustRight Scotland.
Thank you. I think when we met last week, Ms Fleming, I think the first thing I said to you, did I not see you on television a couple of weeks ago? And I think you confirmed you were, and that you had been publicising the case of a lady who could not obtain legal advice in the Highlands, and you were indicating the difficulty that she was experiencing. And that I think is one of the points that you make in your statement.
That's correct, yes. And I think that particular media campaign is around a client, I think that's, I believe, supported by Women's Aid. But yes, that big issue around that is around the legal aid provision and lack of access to legal aid solicitors. And we have been doing a lot of work at the Scottish Women's Rights Centre around the legal aid crisis and issues around protective orders specifically, and we recently launched our briefing paper on the legal aid crisis with a focus on protective orders and work that can be done in that area to improve access to justice for survivors. And that is a lot around the campaigning work that we've been doing in the last few months.
Can I just take you to a section of your statement? It's part 6, and it begins at paragraph 65, which is the service response. And there are just 1 or 2 points I'd like to ask you about this section, because you talk about the way in which the pandemic and the demands of the pandemic influenced the way in which you, as an organisation, had to respond. Can I pick up a point you make in paragraph 68, which is in relation to the SWRC helpline? And you say that at the beginning of the pandemic, it was recognised that women may need urgent legal advice, and so on the 14th of April 2020, SWRC launched an urgent legal advice surgery. Now, I'd just like to understand the context of that. That would have only been a matter of two weeks after the first lockdown. Yeah. Obviously, one of the things we've heard about in the inquiry has been the way in which people had to anticipate what was happening and what was likely to happen. As early as that, when you established the urgent legal advice helpline, you were identifying at that stage the impact that the pandemic was going to have on women and children. Am I right?
That's correct, yes.
Yep. And that, if I can put it this way, was that obvious to you that that was going to happen?
Yeah, yes. Yeah, we had we were lucky enough, if I can say that, that our centre, our JustRight Scotland, used a online system. So we were mostly paperless. We did have files, but we didn't rely on paper files. But I know a lot of law firms, you know, at that point did have paper-based systems. We were really lucky that we were able to just straight away work from home. So before lockdown, I think a few days before the lockdown, we were our position was that we were going to start working from home, and so we were able to really quickly. We had an idea that we were going to have to move our systems to remotely. So we knew we had to move our helpline. So our helpline was based in a room using a telephone, but we had to change that to an online system. But we were able to do that without delay. We didn't have to cancel any helplines, so we did it really quickly. And our in-person legal surgeries, which used to be based out of individual rape crisis centres and women's aids offices, we moved them to remote. So we just moved them to online appointments. Again, we didn't cancel any of those legal surgeries. We moved everything really quickly. And what that really afforded us the opportunity was to hear survivors as the lockdown was being announced and as the lockdown was continuing. We were hearing from survivors the impact and the concerns and the worries they were having about continuing to live with their abuser, or their abuser being able to target them. And really quite quickly we were seeing that we initially had worried actually that there was going to be a drop in the use of our service, but we didn't really ever find there was a drop in the service. Actually it increased, and what increased was the urgent nature of the referrals we were getting. What we've always dealt with protective orders and family law issues, but protective orders became a really high percentage of what people were requiring and needing some support around. And also general protective orders like exclusion orders, where a survivor, a perpetrator is living in the house, and just advice around these things and what they can do, and also around safety planning. So what a survivor would do if they were stuck in the house, or if the perpetrator did come to their house and they weren't sure what the police were doing at that point. So we had to really quickly think, what are we going to do? How will we provide an urgent service? So we introduced the urgent legal advice surgery, which was an additional weekly legal surgery that we introduced for emergency cases, such as protective orders or child contact cases where a perpetrator had retained the children or hadn't returned the children. And like I said, safety planning, just giving people general safety advice. So we did do that reasonably quickly. It was quite evident to us that that was going to happen. The other thing that we did, and sorry if I'm going on a bit, but the other thing that we introduced was our online advice service. So all of our services required somebody to either call us or have a video call appointment with us, but it was quite obvious very quickly that that wasn't going to be possible if somebody was living with their abuser. When we look at our statistics of our service, the majority of the calls that we receive, so a high proportion, of the calls that we receive are from women who are experiencing domestic abuse. And that then impacts the type of advice that we give. It's usually family law-based advice, protective orders. So then we knew that where somebody was living with their abuser, they weren't going to be able to phone us, but also that they would have childcare issues, so that the survivors would be at home with their children. So we developed the other service, which was our online advice service, which was different to anything we'd done before, and it had unprecedented demand for that and for the urgent legal advice surgery, which was pretty much booked up the whole time that we had it available.
I think what I'm particularly interested in, I'm very grateful to you for that explanation. But what I'm particularly interested in is that the service users that you provide advice to were, from your perspective, an obvious group who were going to be potentially and actually adversely affected by the lockdown that came with the pandemic. You would have appreciated that from the outset.
Without question, and worryingly so. It was a huge worry for us, thinking about survivors not being able to access the services that they need, and being locked at home with their abuser was terrifying for us as service providers, and I can't imagine for a survivor living in that situation.
You do mention in paragraph 71 of your statement that during the pandemic, and I think you're really talking about principally the early days of the lockdown, the helplines became notably more complex in the sense of the issues that were being presented. Now, I'll come on to safeguarding in just a moment, but we've heard recently then from Dr. Scott that the complexity of issues that women may have in the context of domestic abuse and violence are not limited simply to physical protection. So they are also, can include, as has been pointed out, matters relating to tenancy situations, child protection, child access. And is that what you're envisaging in terms of the complexity of issues?
Yeah, I mean, I mean, yes, but that's always been. I mean, a survivor, whenever they approach our service, is never looking usually just for one advice about one thing. It's always a range of issues that need to be dealt with, child contact, you know, and then there'll be loads of things that kind of come from that. I think what the complexity was during the pandemic was part and parcel the measures and the guidance that was available. What was available, what a survivor could and couldn't do. Survivors are coming to us with really complex and unusual questions that honestly we didn't always have the answer to, because we didn't know. I mean, we were checking guidance. We were obviously trying to make sure we were as up to date as possible for survivors, and putting that on our publicising that in legal education that we were promoting and putting online. But yeah, the complexity came from the dangers of the situation. So the concerns for the safety of the survivors, which became inherently more dangerous, and then the complexity of the pandemic causing legal advice to be more complex and.
Yeah. You do mention safeguarding, and I'd just like to touch on that. You're using that in a not, as I understand it, in a not strictly legal context. You're looking at it as essentially in providing a safe refuge, or protecting somebody from the consequences of gender-based violence and abuse. Is that correct?
In this context of safeguarding, which I know I appreciate is complicated because there are legal contexts of it, yes. But in this context, what we're thinking about is where a survivor would approach us, our service, and be displaying severe mental health concerns and require safeguarding. So we require to safeguard their position. So their approach, what had happened during the pandemic was that we had a significant, unprecedented increase in survivors presenting as extremely vulnerable, and in many cases suicidal, and presenting with suicidal ideation. And I mean, our service obviously deals with survivors of gender-based violence who are traumatised as a result and have extreme mental health issues as a result of the abuse that they have suffered. However, pre-pandemic, where our survivor would usually come to our service through another support service, either being supported through the NHS or through one of our sister organisations, and then they would come for legal advice, because legal advice really should be the step after you've received support and got to safety, and you're in a safe situation. What actually happened was that because of the unprecedented demand on all of our sister organisations, but also on the NHS and the lack of services that were available during that time, survivors were coming and presenting to us as a frontline service, and so they hadn't spoke to anybody else, or they hadn't been able to get to anybody else, and so we were having to put in place our safeguarding protocols that we have had to use obviously in the past when that happens, but not as regularly as in the pandemic.
You mentioned that safeguarding issues were, as you put it, so concerning that you introduced additional training and protocols for all staff who are working in that area. Without going into the details of that, so far as the impact on your staff was concerned, or those who were providing those services, what was that at that time?
I think, and I've heard as well from our other sister organisations today and at other times, I think the inquiries heard that the impact on our staff who are doing obviously a very demanding and difficult job, dealing with that during the pandemic was difficult in itself. But our staff, so we're a legal centre. We have advocacy workers who are employed through Rape Crisis and sit within the Scottish Women's Rights Centre, but they're legal advocacy workers, so they help with legal issues, and we're lawyers within JustRight Scotland and caseworkers. We are not support staff. It's not what we should be doing. It's not what we're trained in doing. We have a level of training to be able, obviously, to deal with very complex and provide a trauma-informed practice and service. But it very quickly changed to requiring to be a frontline service providing a level of support, because that's just what survivors required. So it was obviously extremely demanding, but it was also, like I said earlier, it was a really worrying time because we were worried about survivors and what was actually available and what the changes were being made.
So it was a situation where what was being relayed to you and your co-workers was not simply something you could leave on your desk. You remained concerned for the safety of those people that you were acting for, I take it.
Yeah, I mean, yes, certainly, and I think, I mean, that is something that obviously is. I mean, it's a very difficult subject that you're dealing with anyway, yes. But you have to have a level of being able to, deal with it and deal with other survivors. But during the pandemic, what was particularly challenging is we were doing it within your house, so we were working from home, and it was challenging to then leave that, but also knowing that a survivor was then stuck in their home, dealing with this situation. So yeah, it was challenging.
You also mentioned a triage system that you introduced. Could you just explain how that operated? So previously, before the pandemic, and actually during the pandemic as well, we operated our helplines, our legal helplines, were operated by our solicitors, so the Scottish Women's Rights Centre solicitors. So we would be the frontline person answering the calls from a survivor who was phoning up to get legal advice and information. During the pandemic, just like I've said, we received a higher influx of complex calls with safeguarding issues, and that then meant that the biggest impact that had for us as a service provider was that we were really unable to provide legal advice on those helpline calls. If a survivor is phoning up and they are experiencing a mental health issue, or they are feeling suicidal, or there is some big impact happening in their life right there and then giving legal advice isn't what we should be doing. What should be happening is they get support to allow them to then to be able to process the legal advice, and they wouldn't be able to take it in, and that was becoming really clear and evident. And so not straight away, so not as quick as we did our other services, but I think potentially a year into the pandemic, I would need to come back with a date for when we started our triage, but a while into the pandemic situation, we introduced our triage helpline, which was where our advocacy workers would triage calls that were coming in and then create callbacks for our solicitors to call back the survivor. What that meant was the survivor would be supported in the first instance, so triaging that call
to support them, get them signposted if they needed to be signposted to one of our sister organisations like Women's Aid, or if they needed any other kind of support in the first instance, and then a legal callback would be made for a solicitor to be able to give legal advice. Actually, I would say one of the positives of the situation is that has remained. We've kept that in place because it works really well. It's a great system to have, and it supports survivors in a really well-rounded way.
So a benefit that emerged out of a difficult situation.
Yeah, I would say so, yes.
Just while we're on the service response, can I just mention, and thank you for the evidence and submissions that you've provided the inquiry with, and which you refer to in paragraphs 80 to 82. Thank you very much for those. Those are documents we are going to be and are looking at. Can I also say that the inquiry is conducting some hearings on equalities and human rights in Scotland during the pandemic. So what the paper that you refer to in paragraph 81 is something that we will be taking into account in that section of our hearing. So thank you very much for that. Can we go back to some of the specifics that you refer to? Child contact, you highlight in paragraphs 19 and following of your statement. Is that because child contact is a situation where there may be ongoing contact between a person who is being abused and the abuser, but in the context of there being access to a child, and that can be in itself a situation that is manipulated? Yes.
So it's well known that at the point of separation in an abusive relationship is quite often a point of an escalation of abuse. It's where an abuser loses control of the situation, and their behaviour quite often escalates and bleeds into other areas of the woman's life. And child contact is one of the ways in which a perpetrator can continue their hold of control over a survivor. It's another form and means of abuse. Perpetrators often use the court process and our legal processes, such as child contact arrangements, which are obviously out with the court process sometimes, to continue their abuse. And it's a form of abuse within the court system. It's a form of abuse through legal processes, and child contact is a way that a survivor can't get away from child contact. The child, until it reaches a certain age, may be required to have contact with that perpetrator, and it's a means of continuing that contact and a way of continuing that abuse.
Yes. You make reference in your statement to guidance issued by the Lord President in relation to contact during the pandemic. Now, I suppose contact can occur in or be regulated in a number of ways. It can be either an informal or formal agreement between the two parties, the two parents of the child. Or it can be something that has been imposed on the parties by the court. So there are various situations that one can be dealing with in terms of physical contact. Did you feel that guidance issued by the Lord President was helpful?
I think a big difficulty with the guidance that was issued was that the measures were continually changing, and so it's appreciated that the Scottish Courts and Tribunal Service required to update its guidance regularly and to keep up to date with those measures. But I think there is a concern in terms of what was thought. How will this impact a survivor of domestic abuse? And I don't think that was necessarily considered, because part of the guidance that was issued was that if one party to a child contact arrangement, now that could have been, they were particularly thinking about child contact arrangements through court orders, but as we know, child contact arrangements are also agreed kind of voluntarily between the parties. But if one of the parties unilaterally on their own decides that I can't allow this contact to go as it has been, I need to change this because of a COVID measure, so something that's a COVID issue, so they require to isolate, or they are a vulnerable individual that needs to isolate, or some other issue related to COVID, then what the courts were saying is if you change the court order or the court arrangements, then you must put in place some other form of contact, either through telephone or video call, and it was about being reasonable in that, in how you would allow the contact to continue and facilitate. Now, obviously, if a child was isolating with her mum or their mum, and they had COVID, then it's fair enough that that child wouldn't be able to go for contact. And I understand that the court was thinking about how will we facilitate those situations, and these can't all come back to the court to be regulated because it's an instant thing that's happening. However, what that meant for a survivor was that they felt they had no other option than to allow that contact to happen through video call or telephone call within their own home. They felt trapped within their own home to allow those video calls to happen. And what we know from survivors is that perpetrators were using those video calls and telephone calls to monitor what was happening in the house, to check up on the survivor, and also to continue abuse, so to be threatening, to say things to the child, to continue abuse through the child. And we also heard of occasions where the survivor were so worried to not allow the contact to happen, but it was affecting their mental health so significantly that they didn't know what they could do about it. So they were confused about the measures and what was in place.
I take it also contact centres, which are sometimes used to secure independent oversight of contact arrangements. They were obviously closed.
Yes, so I think there was differing positions across Scotland depending on when the measures were in place and at what point the measures. But we're aware of situations where survivors, the contact was ordered by the court to take place through the child contact centre, but those centres were closed, and there was no clarity or clear guidance in terms of what should happen in that case, and what that contact should look like.
Now, we heard earlier this afternoon Dr. Scott expressing an opinion on matters of contact during something akin to lockdown, if there were to be another situation where, as I recalled her saying, there should be a cessation of contact. Do you agree with that?
In all, and I don't recall that part. Can you give me more context to what
yes,
you were saying? Sorry.
To avoid the situation where there could be manipulation or abuse of the contact arrangements, the contact arrangements should be suspended.
I think it depends on the circumstances of the case.
Is that not fair? I mean, I sort of hate to step in here, but as someone that's sat as a family judge for 10 years, I've got some knowledge of this. It is all pretty much dependent, as you said, on the circumstances. There are a multitude of circumstances that can arise, and I think if Dr. Scott, I can't remember exactly what she said, we'll have to look at that, but if she said that in an analogous situation to a pandemic, then all contact should cease, that would be, I would have thought, I think you're agreeing with Ms. Fleming, that would be to ignore an enormous range of possibilities. It's got to be far more nuanced and fact-driven than that, surely.
I would completely agree, and I imagine that that Dr. Scott was perhaps discussing in cases where there are serious concern. But in any event, our advice always would be to a survivor that if you're concerned for safety, that contact can stop. The difficulty during the pandemic was whether or not it could be taken back to the court or not, and how emergency or urgent was that considered. So I think all of that would need to be clearer, but it would need to be fact dependent on the case.
I mean, I think possibly you'd agree with me as well that particularly if it's court-ordered contact, then if a circumstance such as you presage in paragraph 20 of the paragraph we're talking about occurs, it may be desirable, it may be sensible for it to stop. And it would be far better if that could be put quickly, immediately before a court for a decision on that. But you're quite correct, at least at the beginning of the pandemic, that wasn't possible.
Yes.
Or was very difficult.
And even when it was possible, so survivors still didn't know if they could or not. So the messaging wasn't clear in the public. So we knew as legal professionals, but lots of solicitors were furloughed, and how was a survivor going to get that information when they couldn't access that legal advice? So yeah, very much fact dependent, and I think that for future, in terms of if this was to happen again, I think it would very much be about learning from what we've been through, but also considering how each and every measure that's put in place is going to impact those who are underrepresented and marginalised in the community, and those who are the most vulnerable, and women who experience domestic abuse certainly are.
Which raises a very difficult question of dissemination of information.
Yes.
Yeah, which one of probably my jobs is to try and think of things that we might do about that.
Yes.
Thank you, my lord. We just go to the situation where somebody is in a home and is suffering domestic abuse or controlling behaviour. I suppose there are, it's far too general, but there are alternatives that may be available to that person, and one would be to leave. That presents difficulties, and I think you've highlighted those, and those difficulties are quite obvious in the situation of a woman, particularly who hasn't got access to funds.
Yes. And I think a lot of it as well, again, just going back to the messaging, the messaging was to stay safe at home or stay home. And what we were hearing from survivors when they were phoning our service was that they didn't know what they could do. Could they flee? And we were having to tell survivors, you can. If you are concerned for your physical safety, of course you can flee and leave that situation. But then we were then hit with the other situation, was where would they go? Because we've heard, I think, from Scottish Women's Aid that refuge was full. There wasn't the space because of required measures, and we also know that we're in a social housing crisis, and that there's issues with housing, and so survivors were very much, although even when we could tell them that you can leave and leave for your safety, they didn't know where could they go. They would maybe have parents who were vulnerable and isolating. They might have family members who didn't want to, share accommodation because of concerns around safety, and then all of that on top of the other barriers that survivors just always experience around economic abuse and the financial burden of leaving, all of which were exacerbated and highlighted during the pandemic.
And there could also be advised, and I use that word perhaps reluctantly, but they can be advised on their situation by the abuser, which would be used by the abuser to manipulate the situation again.
Well, I mean, I think that's correct. I mean, an abuser will quite often use threats, and when rereading my statement, I was thinking about how the COVID pandemic was almost used as another form of abuse by perpetrators. So we often hear about immigration abuse. So where somebody who has an insecure status or their immigration status is relied upon their spouse, where they are going to try and leave a domestic abuse situation, a perpetrator will quite often use that as a means of control. If you leave me, or if you do this or you do that, I will tell the Home Office. You won't be able to get immigration status secured. And actually what we were also hearing during the pandemic is the COVID pandemic was being used in that same way. If you leave, I'll tell the police that you're breaching the lockdown measures. You'll not be able to do this. Also using it as a threat in terms of you're risking our child's health, you're risking your family's health. I've got elderly parents, I need to keep the child. All of that was being used as another form and a tool for the perpetrators to continue their abuse. And like you say, to keep them at home in some occasions.
Yeah.
And Mr. Gale, if I can come in, I think, on what we're discussing on giving advice to women to just leave their accommodation, it's important to remember that for some women who are also migrants, they might be subject to the no recourse to public funds, which is a measure on their, when they have temporary visas to stay in the UK, which limits their access to state support. So, for example, there will be instances during the pandemic where women would have to choose between leaving the perpetrator because they would provide food and accommodation, and facing homelessness and destitution, because if the refuge is provided by the government, then they're not entitled to have it. So it's important to also recognize that element.
So is there a solution to that?
To remove the no recourse to public funds.
Okay. I suppose another alternative to somebody in a confining and abusive situation is to make a complaint to the police. What was your experience of the success or otherwise of that during the pandemic?
So we did hear of survivors who had been threatened with the police being aware. So just more generally in terms of the work that we do, we hear of dual and malicious reporting regularly. So it's a huge concern for survivors where a perpetrator would maliciously report them to the police to stop them from, just to, as another form of abuse, but also it could be to try and control child contact proceedings, or if they have raised an action for a protective order, they might do it retaliatively. But during the pandemic, as I said, a part of that would be threatening that they are breaching measures and reporting them to the police for doing that, or reporting them to like social services, social work, or making other types of complaints in other areas. That is a regularly used, and I would say was certainly something that was threatened during COVID and that we heard about.
Well, coming a little to delays in the justice system, both civil and criminal, but there would also, I suppose, be the possibility of seeking access to legal advice, and that's perhaps where your organisation comes in and other organisations come in. In terms of physically doing that during the pandemic, and I appreciate what you say about your helplines and so on and so forth. What were the difficulties in that?
I think there was real difficulties for survivors trying to access legal representation. As you say, we had our helplines and our legal surgeries, but I mean, we are a small government-funded service. We can't and we shouldn't be meeting the demand of the whole of Scotland, and we are a nation and a national project. And so we although we hear a lot we hear a lot of calls and we speak to a lot of survivors, it isn't everybody, and so we're well aware that and just from hearing from survivors how difficult it was for them to contact solicitors. So as we know, at the start of the pandemic, measures were introduced very quickly And from what we were hearing and what we were seeing from our colleagues and other law firms, it was quite difficult sometimes to try and implement those measures. And so I think there were periods of times where there was confusion around what solicitors were doing and whether or not they were working. Could they work from the office? Were they working from home? How would they implement those changes? And then we later started to hear about solicitors being furloughed, which is understandable. And I think that Dr. Scott spoke about the women being the majority of family law solicitors, and so women through default become the person who has to deal with the childcare concerns, and so quite often the solicitors in the family law field, which is primarily the kind of field that we are dealing with for survivors, were furloughed, not working, or working very reduced hours. And so where a survivor had a solicitor, that they might not be able to access that solicitor. And then we began to hear increasingly, as the pandemic moved on and as we carried on, that solicitors weren't providing legal work under legal aid. So we're aware that there is a legal aid crisis, and that survivors are reporting to us that they have to call anywhere between 30 to 50 solicitors to try and find a solicitor to provide them with legal aid representation for child contact, for protective orders. It's almost impossible, I would say, to find a solicitor doing divorce under legal aid. And so survivors were struggling, I think, to get legal advice and representation.
Also, I suppose the practical step of trying to obtain that advice, if you're living in a confined space with an abusive and controlling individual who's monitoring what you do, listening to your phone calls, checking up what you're doing online, I suppose that, again, is a difficulty to contact even helplines such as your own.
Yes. And quite often what we find is that survivors contact our service while they're still in an abusive relationship because they're starting to prepare to leave. So they're wanting to prepare and get the advice that what's going to happen, because a big worry is quite often what's going to happen with the family home, what's going to happen with the child contact, because those are your two main things. That's your accommodation and your children. And what's going to happen about these two things? And they're usually economically dependent on the perpetrator. So then they're considering, what are my options, and they need to come and get some initial advice. So a high majority of the people that we speak to are still within that abusive relationship, and so trying to call us, like you said, while they're living with the abuser and they couldn't leave the house. We either had survivors who were using their, what was it, like, I can't remember how long it was we had for exercise, but you could go out for an hour or 20 minutes or something. So they were using that time to call us, or the perpetrator, they would be saying, he's out, he'll be out for 20 minutes on his walk. And we would have to say to them, well, I mean, if he comes home, hang up the phone, just get back in touch with us another time. So it was quite tense as well for the survivor, and that's partly why we introduced our online advice service. But for solicitors who don't have helplines, they're providing their service. I can't imagine how difficult it would have been for a survivor to try and get in touch with the solicitor, and for the solicitor as well to try and provide that advice to their clients.
Again, with all those concerns in mind, do you have any view as to ways in which, in the event of another pandemic, issues such as this could be addressed?
I think the main thing and the first thing that could have happened, I think caused quite a lot of damage, was the messaging. So I think being really clear about that and publicising the messaging that survivors can flee abuse and that they can, and also around services still being available, so the courts still being open to emergency, urgent cases, the police still accepting reports of abuse and still responding to those, because all of these things were happening. It's just that survivors didn't know it, and services as our own being available and open, and the funding, for example, that Scottish Women's Aid and Rape Crisis got was obviously so important to allow those services to continue going. So I think the messaging, I mean, it's never going to be. I also think that obviously the consideration around actually what the lockdown measures and all of that kind of stuff, but that's not for me to comment on.
Yeah, but you could. I think we heard from one of the witnesses earlier today, or possibly yesterday, someone referred to a more nuanced lockdown. Was a phrase that was used. I today or yesterday, one or the other. A more nuanced lockdown, by which I took to mean, rightly or wrongly, that rather than simply having a blanket lockdown, if we were in a situation whereby, in the event of a very serious illness-based pandemic, there was a need to restrict movement as much as you could, you would still have a system whereby as much of normal civil society as existed before continued to function.
And if there had been gender competent decision making in terms of when those lockdown measures were put in place and considered, and the consideration of the impact on victims and survivors of gender-based violence had been considered, then they could have provided a more nuanced position.
And all that would require to be done in advance.
Yeah.
As a matter of planning.
Yeah.
You can't do all these things in the first week after you've got a disease thumping on your door.
And just one last thing, I think the other thing would be around refuge and temporary accommodation. Where a survivor can't go to a vulnerable and isolating parent's house or friend's house, and they don't have that social network, which quite often survivors don't have because a perpetrator has isolated them, and so they don't have the family and friends to reach out to. They require refuge and temporary accommodation, and we're hearing from our other sister organisations that just wasn't available, and we know that we're now in the midst of a social housing crisis. And if this was to happen again, then that would be extremely concerning. Where would a survivor go if this happened again?
One of the points that you alluded to earlier, and I'd just like to take up with you briefly, is the effect on mental health. I think you've indicated in your statement that you and your colleagues give advice on a range of subjects, which would include, for example, criminal injuries, compensation claims, personal injury claims, and also in the context of protective orders for individuals who have been subject to gender-based violence. And the need in that situation to obtain, because of the need perhaps to front-load the application, the need to obtain advice on the mental health impact on that person. What were the difficulties in that during the pandemic?
Yes, so this is something that we've seen really developing since the pandemic has happened. But just to kind of preface that with, when a survivor is accessing justice, so they've tried to access the criminal justice system and that has failed them. Either there was insufficient evidence, or it's not been successful, or that process hasn't been successful in some way. Another form of justice that they can possibly seek would be to seek put an application in for criminal injuries compensation, or to seek an action for civil damages, also known as a personal injury action, where you seek compensation as a result of the harm that has happened to you. But for a survivor, it never is about the money, because no amount of money could ever compensate the harm that's resulted as a result of gender-based violence. But what it is these forms of justice allow them to be heard, and it's a finding by an authority or by the courts that this is more likely to have happened than not, and it's recognition of their abuse. So we help survivors quite often with criminal injuries applications, and we also help with civil damages cases. And in order to proceed with those applications, you have to be able to evidence the harm. Now, obviously, often in domestic abuse situations, there is physical harm, which can be evidenced by medical records. But predominantly, and the biggest harm that happens as a result of domestic abuse and gender-based violence is a psychological injury that results, which is obvious. It's often permanently disabling and significantly impacting on their lives. Previously, before the pandemic, what we found is that survivors were coming to us, they would already have had the diagnosis of a mental injury, because they would have engaged with the NHS, went through the system, had support, and would have received a diagnosis. But now what we're finding, and what we've been finding in the last few years, is that survivors haven't been able to access the NHS in that way. They're often coming to us without having received a diagnosis, and so to access criminal injuries compensation, or to make an application for a personal injury case, And also in other actions like protective orders, where, like you're saying, we want to front load those actions and show the harm that's being caused, we would often now require to seek our own reports, reports to show the harm that's been caused. And actually what we've found that's showing is that the impact on survivors' mental health has been significant as a result of the pandemic. Survivors are reporting to us that now, and still are waiting on waiting lists that can be anywhere from 6 months to over a year to access mental health support. And a big issue around that is that where a survivor is still engaging in like the criminal justice system, and we've heard about the delays in the criminal justice system, there's certain mental health treatment that they can't access because their trauma is ongoing, and so it really restricts what they can access. And so where the waiting lists are so long for all of the different types of mental health treatment and support, it's having a knock-on effect on their ability to access justice.
Thank you. And obviously the availability of practitioners to provide such advice to your client or the person you're advising is also, or has also been now restricted, is that right?
That's correct, and a privilege of our service is that we're able to provide our service users with advice under legal aid and through our government funding, and so we can seek these reports. But if a survivor is doing their own criminal injuries application or has been unable to secure a legal aid solicitor, they would then be faced with paying the costs of securing that report, and it can be anywhere from like £750 to £2,000. It's an unachievable amount for a survivor to.
Can I briefly talk about the position of migrants, including asylum seekers, which you deal with paragraphs 45 and following of your statement, and I'm interested particularly in what you say at paragraph 46, where you say the migrant community has faced some of the worst outcomes from the pandemic, from loss of income to loss of homes and loss of life. You just expand on that a little, please.
Of course. So evidence really tells us that the risk of COVID-19 has been twice as high for migrants compared to native-born individuals. And this is really because migrants were during the pandemic, but also are today, more likely to be living in poverty, more likely to be in precarious and underpaid jobs on zero-hour contracts, if and when they are allowed to work. And they wouldn't have access, many of them wouldn't have access to safety nets, for example, the furlough scheme that many of us were lucky to have. And it's important to say that those inequalities existed before the pandemic, and it goes back to what we were discussing before. It would have been very difficult to fix all of those things at once during the pandemic, and that's why they need to be seen as intersecting inequalities so that you fix them before the problem starts. And now, a lot of those inequalities for migrants really stem from what we call the hostile environment, which refers to the system that was created back in 2012, even though it started before then, by the then Home Secretary, Theresa May, with the aim of really making life really quite hard for people that couldn't prove the right paperwork in the UK. And at the time, she said that in Britain, we should create a really hostile environment for illegal immigrants. And I think it's really important to say that there is no such thing as illegal immigrants, because there isn't such a thing as illegal people. However, we continue to see that there are a lot of policies and legislation in place that really create this type of destitution. So during the pandemic, for example, people were moved by, they were living in different types of accommodation within a community in Glasgow, because they used to be the only dispersal city in the UK, and then it was changed with very little notice from the Home Office. And it meant that any local authority in Scotland could become a dispersal city without having the adequate resources or infrastructure to help that group of people. And as Lindsay had said, it becomes really quite hard for people who are outside of the central belt to access basic needs, including legal advice. We know that outside of the central belt, there is one solicitor in Dundee and one in Fife, but there are about 600 people placed in hotels. So it's really quite hard to meet their demands. And what happened during the pandemic is that people were moved into hotels without the right infrastructure in place, without giving information to local authorities and third sector organizations. So it means that there wasn't available support, and it resulted in great injury, harm, mental health problems, which resulted in the tragedy of the Park-In. And it's a system that was unsustainable during the pandemic, and it remains unsustainable today. Within that, and I know that we're pressed for time, I just wanted to highlight the asylum support rates, because, as we highlighted in our statement, when people seeking asylum are housed in hotels or somewhere else where food is provided, they receive about £8 per week. If they actually are in different types of accommodation where food is not provided, then they're about £49 per week. And that has to include food, clothing, basic necessity, and also travel expenses if they need to go and see their solicitors. And the majority of people that are seeking asylum are prohibited from working in the UK. And within that group, as we already highlighted, many of them have the no recourse to public funds condition imposed on them. So they're really stuck in a catch-22 situation, which was incredibly heightened during the pandemic.
I'll just ask you one point. What you say in paragraph 51 of your statement, you talk about the Park-In situation, and you go on to say, as well as the inadequacy of the response by the Scottish Government and Scottish local authorities, which falls significantly short of a rights-based approach. And I think you're talking there about the provision of accommodation, principally. Can you just explain why you are of that view?
Well, we are of that view because if you really wanted to take a genuine human rights based approach to COVID-19, and also to the recovery phase, then you would really have to think about all people. And we continue to think in silos. And I think that's the problem when public authorities and governments don't take an intersectional approach. It's important to think about migrants. Within that category, we'd have people seeking asylum, refugees. It's important to think about disabled people, people who've been trafficked, as we've done in our statement. But it's important to think about how all those intersecting types of disadvantage interact with each other, because one could be a woman who's also disabled and migrant at the same time and experience all these different types of discrimination all at once. So the response during the COVID-19 specifically to this was insufficient, because the Scottish Government does have a responsibility, especially because there is a strategy called the New Scots strategy, which is about welcoming people who are not from Scotland that decide to make Scotland their home. And the idea is that they should feel welcome from the first day they arrive in Scotland. And whilst immigration is a reserved issue of the UK government, other policy areas are devolved. So the Scottish Government could look at areas like education, policy, and the justice system in a way that really includes this group of people. And until people are still housed in unsuitable accommodation like hotels, then there should be adequate funding in place for local authorities, but also for third sector organizations that provide a vital support to people housed in hotels.
Thank you. Can I also thank you very briefly for the section of your statement on the legal framework for evaluating the disproportionate impact, and obviously this inquiry will have regard to that, and given the time, I'd like to just take you to the final paragraph of your statement, where you say this inquiry aims to, as part of our terms of reference, to establish the facts, identify the lessons that need to be learned, and make recommendations to Scottish ministers, so we are better and prepared in the future. And you say to achieve this aim, your organisation believes the inquiry will need to consider the multiple and compounding discriminations experienced by individuals, and to ensure that any recommendations made are fit for purpose for those who need them the most. Now, we take from all that you've said that as a summary of your situation. Can you briefly, is there anything further that you would like to add to what you've already discussed with me this afternoon?
I think just the point that when we take an intersectional gender-based approach, we really are forced to think about all the different types of oppression, inequality and discrimination that different groups of people face. And that prepares us for future crises. We understand that everything that has to be done in response to the COVID-19 pandemic had to be taken in a really quite fast fashion, but there is now time to reflect, especially because, as we've already highlighted, some of the things that happen in the groups of people that JustRight Scotland works with are not about high numbers. They may not be about large quantities, but that shouldn't have a place, because the severity of what happens to those people is so grave that they shouldn't be left behind in the way that they were. So the aim for us in providing this statement is in ensuring that when we talk about these groups of people, we really think about all the different systems of oppression that exist at the same time, without having to address all of these different issues in silos, because otherwise we will continue to have in silos responses.
Well, thank you very much to both of you for the evidence that you've given, my Lord. Unless there's anything my Lord wishes, I appreciate we've gone over time, and I apologise for that.
I do apologise for Mr. Gale. Thank you, ladies.
Thank you.
That's all. Tomorrow morning at 10 o'clock.
All right.